Welcome to Sakshi TV's special immigration show with attorney Ms. Prashanthi Reddy from Law Offices of Prashanthi Reddy PLLC. Ms. Reddy needs no introduction, but if you need consultation, please log on to reddyesq.com for contact information. Today's topic is the USCIS FAQs on adjustment of status, Outlook for 2023. Hi, Ms. Reddy, how are you doing?
I'm good, Tony. How are you?
Very well, thank you. So, should we straight away jump into our topic?
Yes, absolutely.
Right. So, Ms. Reddy, regarding the employment-based adjustment of status, for fiscal year 2023. So, Ms. Reddy, could you probably give us an estimate or a prediction of how many family-sponsored or employment-based immigrant visas from the USCIS and the DOS will use in the fiscal year 2023?
Yeah, so this one is interesting because earlier we were talking about 2022 family numbers, then we know how many numbers have been used. For 2023, DOS currently estimates that there will be a total of 200,000 employment-based numbers. This is due to unused family-based numbers from this year that will be falling into the next year. Next year starting in October. The fiscal year, as you know, starts in October. So we have this year 60,000, not 140,000 like we had last year, because we know that Department of State, the consulates has been doing a better job of using the family-based visas and approving more cases. So this year we only have, a less number. We have 60,000. So they've added that, and so they give it a grand total of 200,000, as opposed to last year where they had 281,000. So that's the number of total number of employment-based limit. That's a total employment-based limit for F1 for next year, 2023. And USCIS continues to say that they're committed to using all those numbers like they did this year. They did a pretty good job of using all those numbers. It's difficult to say how many numbers, USCIS has said that it's difficult to say how many numbers have actually been used at any given point of time, because there is no single database which gives it. They're separate databases and they give incomplete information. So there is USCIS's publication of the quarterly reports, but that doesn't include the visa issued at the Department of State. And so, it's an incomplete picture. So every quarter, it's hard for anyone to look at some statistics and see where they're at and how many cases, how many numbers they have left.
Right. So that brings us to the next question. If let's say in a particular employment-based category, some visas are not required, would that mean that they can be made available in other employment-based visa categories?
Yes, absolutely. So Congress has established a statutory provision that allows for the flow of visas from one category to another. So therefore, but there's only the flow works only one way. So, for example, visas not required in EB4 and those visas, unreserved visas that are in EB5, are made available first to EB1. And then if visas are not required in EB1, they're made available to EB2. And then from EB2, if they're not used, they're made available in EB3. Now, if they're not used in EB3, then there's no way of using those EB3 visas. They don't again go back to EB1 or to 4 or 5. With EB5s, not all visas that are not used go into EB1, because for EB5 they were able to establish a law which allowed them to use the unused visa numbers from the previous years, some of them at least, into the following year. But they haven't done that for EB1, EB2 or EB3. But they've done that for EB5, lucky for them. And so not all the unused visa numbers from EB5 fall back into EB1. Some of them do. So that's how the pattern is, from EB4 to EB5, EB5 to EB1, and then 2 and 3. And then from 3, they don't go anywhere. So they pretty much, they're wasted.
Our next question is, Ms. Reddy, could you explain to us why TOS has retrogressed certain final action dates or applied new final action dates in the visa bulletin for October 2022?
Yeah, so whenever they're setting uh, the visa bulletin for the first one, especially that October is the first visa bulletin for the new fiscal year. The Department of State, especially for the first visa bulletin, has to make reasonable estimates of the available employment-based visa numbers in each category. And then it will collaborate, the DOS collaborates with USCIS and reviews, how much pending inventory is there of adjustment of status cases and how many immigrant visa I-140s have been filed. And then they make a reasonable estimate of new applications that are likely to be filed in that particular month. And then, so then based on that, then they will compare it to the available visa numbers. So it's basically a balancing act between the availability and the demand. So when obviously the demand is higher than the availability, then retrogression has to happen because they have to cut off or stop people from filing new visas because they already have enough pending petitions to meet the requirement for the available visas, right? So that's why they come up with this retrogression or a particular date where they think that the people from this date, if they file, then we'll have enough, green cards for the year. Otherwise, they cannot have the green cards oversubscribed. They cannot have more people filing than green cards available. So they always tend to be a little cautious. It's an estimate, as you can see from my explanation. It's an estimation of how many will file and versus, how many I-140s have been filed. But when they look into this, they do take into account whether that a certain percentage of applications won't be approved. They account for people who have multiple pending applications in different categories. So you could have a family-based petition, you could have an employment-based petition. So they know that from that only one visa number will be used, not both employment-based and family-based. They also consider how quickly the pending applications will be processed. So if they think that that particular application, the processing time is over 1 year, then they don't have to worry about putting that into the number for green card availability for this year. So they look at that also because those pending applications don't need an immediate visa number. Also, they'll take into account if pending multiple petitions were filed within the EB category. So the person, we know with the downgrades and upgrades, people have an I-140 in EB2, in EB3, so they take into account that as well. So taking all this into account, when the amount of demand for a particular category exceeds the supply of visas, visa numbers available, then the country is considered oversubscribed. And then the DOS supplies a cutoff date in the final action date chart to ensure that the visa use remains within the annual limits. That's how it works.
Right. So, as while we're on this subject, I mean, does retrogression affect somebody's priority date or place in line for an immigrant visa?
So no, it doesn't, because retrogression simply means that new 485s cannot be filed. But if a person's 485 has already been filed, it's not going to get denied. It'll just remain pending until the date becomes current. So whenever so the date becoming current means their priority date. That's the date generally for most people. The Department of Labor accepts the labor certification, the first step. That's how the priority date is established. So once your priority date is in line with the visa bulletin priority date or has passed it, then you don't have retrogression. Your date is current. But if it is the visa priority date is before your priority date, the visa bulletin priority date, then that means your case has retrogressed. So this doesn't affect your place in line for an immigrant visa. You will simply get the visa when your turn comes and when the priority date becomes available.
Right. And what about when a category is retrogressed or a final action date is applied? What is a person's path forward to a green card, Ms. Reddy?
So when a visa becomes available to you in the future based on a final action date, um, USCIS will be able to adjudicate the adjustment of status application. They won't be able to adjudicate it as long as your 485 is um, not available. The priority date is not available. So what will happen in the meantime is USCIS will continue to work on your 485 application. They'll continue to make sure that all the documents are, it's complete document wise. And also it'll continue to process your benefits that people usually get while their 485 is pending. So even though you may not get the actual green card, USCIS will continue processing your case. We'll look at it. We'll make sure that it's approvable so that when the dates become available, then it's easy for them to issue the approval, and they will give you benefits or they will process the benefits. For example, you can continue to apply for employment authorization, and if that employment authorization is granted, you can work for any employer, as you know. And usually the EAD is given in increments of 2 years. You may apply for advance parole, which again, if granted, authorizes you to travel outside the United States during the validity of that advance parole document. And upon a return, you will be able to continue to live and work in the US without abandoning your adjustment of status application. So advance parole acts like a visa. It allows you to travel outside the country and come back without having to go to the consulate and applying for a visa. But you have to make sure that it's valid and travel only while the advance parole is valid. Also, you may request for porting AC-21. So if your I-485 is pending for at least 6 months, 180 days to be more accurate, and if your I-140 is approved, then you can ask USCIS to adjudicate an AC-21 application by filing a 485J. In this, you're basically saying that you're transferring your employer and that the qualifying job or the new job offer is similar or same to the job that on the basis of which you filed your green card. So that benefit is also available for you while your case is retrogressed. Also, your children who have applied for adjustment of status as derivative beneficiaries might not age out of eligibility to adjust. So your children can, as long as your children applied when they were under the 21 based on final action dates, if your final action date then retrogresses, your child will not be affected, and they will be continue to be treated as if they're below 21, and they will get their green card along with you. Of course, there are many scenarios in this, and CSPA is a complicated subject, but in general, if they apply based on the final action date, their age is frozen. Also, while you have a 485, you're considered to be in a period of authorized stay, and you don't accrue any unlawful presence. So even if while your application is pending, even if your non-immigrant status should expire, you're still allowed to live, work in the country without accruing any unlawful presence. So these are all the benefits that you have, and all the benefits that are given to you while your 485 is pending, even if your case is retrogressed.
Right. Right. So, Ms. Reddy, when is the derivative child's age, applicant age logged under the Child's Status Protection Act, and and how is that age calculated?
Right, we touched upon that a little bit, but
Yeah.
in employment-based preference categories, a child's age under the CSPA is basically the biological age of the time, biological age of the child at the time of visa availability. less the amount of time that the underlying petition was pending. So to give you an example, if your child was 22 years old at the time that your final action date became current and you filed your 485, then you can deduct the amount of time that your I-140 took to get approved. So say your I-140 took 1 year to get approved, then your child's age becomes 21 because it's 22 minus 1 year for the time that the I-140 was pending. So your child will be treated as below 21 and will be able to then file the adjustment application along with you. But you have to make sure that once the date becomes current, say they don't file immediately because they're outside the country or due to some other reason, the child's age is still locked, but they have to file within 1 year of the date that the visa is available. So again, CSPA is a whole subject on its own, but in brief, this is what CSPA means, and this is how a child's age is calculated.
So, Ms. Reddy, what if a person is applying for adjustment of status? Should they submit their I-693 with their I-485?
So 693 is medicals, and a lot of people have this question because especially if they're refiling or they're filing in a rush because, dates are always moving back and forth, and sometimes you just have a few weeks to be able to file because the next month then the dates retrogress. And it happens very often. It happened in October 2020 as well. So during those times, people generally, the tendency is they try to file without the medicals because, one is because of the time factor and the other is a cost factor. And also because, sometimes USCIS asks for medicals again, even if you have submitted your medicals. So, but I would encourage everyone to file their 485 along with their medicals, and USCIS encourages this as well. For the simple reason that if you do so, then that will help the need for USCIS to send out RFEs, and that will then reduce the processing time and will allow USCIS to use all the available visas. So imagine your date becomes current and it's current only for a month, and your application is incomplete, then USCIS will send out an RFE. And even if you respond to the RFE the same day, USCIS will not process the case the same day. And what might happen is then your case may not be documentary complete for USCIS to actually approve it and, reserve a visa number for you, and you might lose that opportunity when your date becomes current. So important to send not only the medicals, but make sure you send all your documents and send out a complete application so that, there's no issue with your USCIS taking more time to adjudicate your case or sending out RFEs.
Right. So we do have another question from one of our audience. If I did not file a form I-693 with my pending form I-485, should I send in one now or wait for the USCIS to request it, and why?
Yes. So again, a question that's often asked. So that's a good question. If you send out your I-693 medical form without USCIS asking for it, you just send it out to the service center where your case was last, it will not reach your file. So you would have done the medicals, paid the money, done everything, sent FedEx, but it will not reach your file. Because at that moment, USCIS has not asked for your medicals. Your file will not be outside. It will be in some storage room somewhere, and USCIS will not pull out your file to put that piece of information in there. So unless they have asked for information, an officer will not have access to your file, and they will not know where to put your medicals. They will throw them in the garbage. That's a simple reason why you shouldn't submit medicals unless asked for. You cannot submit medicals unless asked for.
Right. Right. So, with the next one for on the same lines is my immigrant visa petition has been approved and I have a pending adjustment of status application. What happens next?
Right. So, if your immigrant visa petition has been approved and you have a pending adjustment of status application, good news. Most probably, depending again on the visa number being available or not, your green card can get approved. But most importantly, what will happen now is USCIS is transferring all adjustment of status applications that were filed in EB1, EB2, and EB3 from the traditional service centers, Texas, Nebraska, etc., to the National Benefit Center. But if your case is pending at one of these service centers, and if the I-140 is not yet approved, they are not transferring those cases. But after the I-140 gets approved, and after Nebraska or Texas has adjudicated the I-140, those cases are often transferred to the National Benefit Center. And then to the field offices, to the Field Operations Directorate, who will adjudicate the adjustment of status application. We know that they have changed the process, and as a result of which they have been able to process a lot more 485s, and they have actually used up all the visa numbers available this year, which is a miracle because they haven't done that for many years. And the reason the USCIS has been able to do that is because they've transferred all their complete cases to Nebraska, to the National Benefit Center, and the National Benefit Center has been forwarding them to the field offices. The field offices are basically those offices that usually take your interview. Those are the offices. So they've recruited the officers at the field offices to adjudicate the 485, conduct interviews if necessary, and approve the 485, or send out requests for further evidence, whatever is needed.
Right, right. So, Ms. Reddy, my next question is, why does the data on the USCIS website show such lengthy processing times for employment-based Form I-485s at the Texas Service Center and the Nebraska Service Center? I know a lot of these questions are probably intertwined, but I think so is the information.
Correct. And also, these are very common questions that everybody has,
Right.
has questions about this. So it's pretty common. So basically, the processing times are different on different websites, especially at Texas Service Center and Nebraska Service Center, and they are significantly longer at these service centers. And hopefully, with the transition of USCIS workload from TSC to and NSC to the National Benefit Center, that timeline might go down a little bit. But in general, it has been long because we have to understand that all those cases that were submitted in 2020, and that's when the visa numbers became available, right? And thousands of applications were submitted. Those were all submitted to Texas and Nebraska. As a result of which, those two service centers had to face, a backlog of thousands of applications. And that's why all the cases that went there, the processing time in those service centers is, 2 years or more. But as I said, with the movement of cases from those service centers to the National Benefit Center, the service centers now are, their time is getting freed up. They're able to process cases faster, and they're adjudicating the few remaining old applications, the ones in which the I-140s are not yet approved. And soon it's expected that the processing times will decrease at these service centers as well.
Right, right. So, Ms. Reddy, how does the transfer of underlying basis request process work?
So, USCIS has created a centralized location for the receipt of, if you're asking for an interfiling case. Let me just pull back a little bit and explain to you what transfer of underlying basis is. So it's also called interfiling or transfer of underlying basis. So interfiling is a more commonly used term. And basically we're saying that USCIS is saying that if you have two I-140s, then you can ask USCIS to adjudicate your pending 485 based on the I-140 that has the best priority date. So if you have an EB3 but you also have an EB2 and both are valid, then you can request USCIS to use your EB2 I-140. And they've created a process for this. Before it was just a letter. Now they're asking us to send the form I-485 supplement J. And they have a centralized location to send this to. So you have to send it to US Department of Homeland Security, USCIS Western Farm Center, 10 Application Way, Montclair, California. So they're asking you to send your applications to this address. You should only send, again, there are two different addresses to send it to. In some instances, most instances, you have to send it to this address. But in some other instances, it could be that you have to send it to the office which is adjudicating your 485 application. So if there's no 485J supplement included, then you should most probably send it to the office where your 485 application is pending. Otherwise, you have to send it to the California address, which I just said.
Right, right. So, Ms. Reddy, how does interfiling really affect, child's age under the CSPA Act, or the calculation of a child's age under the CSPA Act? How does interfiling affect that?
Yeah, that can be tricky actually. So if you're doing interfiling and if you use, say, your EB2, you have an EB3 case, right? The EB3 case took 1 year maybe to process because EB3 cases, a lot of EB2s were downgraded to EB3 at that time. And in 2020, and so the I-140s took a long time for them to process those I-140s. So the advantage for people who had children aging out is that you could deduct the time that I-140 took. So say your I-140 took 2 years to process. You can deduct the time from your child's age, starting from the time. So if your priority date, final action date was available at a certain time, at that time, if your child was 22, then you could deduct the 2 years and your child would only be 20.
Right. So with that, Ms. Reddy, we'll have to end this episode for, on this topic and continue it in the next show. Unfortunately, we have to, but it's like I always say, it's a privilege hosting you with the amount of information that you give out to our audience and with the amount of tips that you do. We're glad to always host you, Ms. Reddy.
Thank you. It's a pleasure, Tony.
Thank you for being on our show. You're watching Sakshi Live. This is Thorini. Thank you.